ADR-LINK is a program of the London Family Court Clinic and matches families referred for service to qualified ADR practitioners. The practitioners are not LFCC employees and do not work for Children's Aid Society offices. They are independent, impartial professionals trained to assist families and CAS to work towards resolutions that will focus on the best interests of the child or children.
As we forge forward and continue working with Indigenous nations, we want to first acknowledge, respect, and recognize the deep connection and historical relationship Indigenous peoples and the land we share, with support, accountability, and much respect to the following traditional homelands and territories of the Anishinaabe, Ojibwe or Chippewa Nation, Haudenosaunee, people of the Iroquois, which includes the United Nations, Lenape, also known as the Delaware, and the Attawandaron, also known as the Neutral, the Wyandot, also known as the Huron. There are 11 First Nation communities in the region of southwestern Ontario and over 120 First Nations in all of Ontario.
The Office of the Children's Lawyer, known as the OCL, is an independent law office within the Ontario Ministry of the Attorney General. Lawyers in the Personal Rights Department of the OCL are appointed to represent children in child protection and parenting cases before the Ontario courts and in ADR matters prior to court. Alternative Dispute Resolution, most often referred to by its acronym of ADR, came into being in 2006 when the Child and Family Services Act, as it was then called, was amended to stipulate that Children's Aid Societies must consider ADR for children who are or who may be in need of protection. The accompanying MCYSS directive requires the CAS to complete and send the OCL a notice form when ADR is proposed. The OCL has discretion under the CYFSA to decide whether or not to assign an OCL. In child protection cases before the courts, the judge is the gatekeeper and decides whether OCL involvement is needed. If so, the judge makes an order and it is mandatory for the OCL to appoint counsel. In child protection ADR cases, the society must notify the OCL, and the OCL decides whether to appoint child's counsel for the ADR. In some cases, there is already an OCL assigned, in which case it is not necessary to send in the notice to the OCL, but just to notify the OCL lawyer of the ADR. In other cases, there may not be a current OCL, but an OCL has been assigned in the past for the child. In any cases where there is not a current OCL assigned, the notice form must be sent to the OCL. The OCL will try to reassign the same lawyer, if possible, to provide continuity for the child. The OCL's Child Protection ADR program has grown since 2006, and it now receives over 900 notices a year from across Ontario. This does not include ADRs that occur in child protection cases before the courts where child's counsel is already assigned. The OCL assigns counsel in all modalities of ADR, including child protection mediation, family group conferencing, and original dispute resolution, and other forms of ADR, such as youth-led conferences, rapid response ADR, new ways for families, or VYSA negotiations that take place through an ADR process. The OCL notice form is a form that is sent to the OCL that outlines the issues for mediation and forms the basis on which the OCL decides whether to assign a lawyer. It is helpful if the society worker filling out the form can provide a fulsome description, as well as the worker's view on whether an OCL would be beneficial to the child or children in this case, and the reasons why or why not. It is important to note any special considerations on the form. For example, if the child has any special needs, if there are intersecting legal issues such as youth criminal justice proceedings, or immigration matters. The OCL aims to provide a diverse roster of panel lawyers competent in working respectfully and inclusively with a variety of communities, including the Indigenous, LGBTQ Two-Spirit+, and disabled communities, as well as racial, cultural, linguistic, or religious considerations, practices, or norms. The OCL also requires contact information for the worker and the ADR service provider, including email addresses and a full list of participants to do conflict checks. If a list of participants is not confirmed at the time of a referral, a list of potential participants is acceptable. The OCL's decision as to whether OCL counsel will be assigned is communicated to both the worker and the regional ADR coordinator by letter. The OCL endeavors to communicate its decision within 7 days of receipt of the notice. If you are experiencing any difficulties receiving a timely answer, or if you have an ADR referral that is urgent, please contact the OCL Child Protection ADR Program Coordinator at the email provided at the end of this presentation. It is also very important to speak to families about the possibility that an OCL will be assigned to their case and to get consent up front for sharing of information with the OCL. While the directive states that the OCL has the right to review the Society's file, due to the nature of the ADR process, this generally takes place as a conversation between the worker and the OCL lawyer, rather than a formal file disclosure. Getting informed consent from the participants at the outset avoids delays and possible problems later in the process if the family was not made aware of the OCL's role. If the family objects to OCL participation, then this may preclude them from participating in ADR services. Whether or not the OCL assigns a lawyer in any given child protection ADR case is very much driven by the facts of that family's situation. However, in general, the kinds of cases the OCL accepts include children at least 8 years of age or older who are capable of expressing their views and preferences, where the involvement of the OCL will benefit the child and add value to the ADR process, when there is involvement of minor parents, parent-teen conflict, youth transitioning from care, expiring TCAs, review of extended care orders for older children where long-term plans are being explored, including kin placement, conditions for return home and access plans, openness mediations, and high-conflict emotional harm parenting cases where independent support for the child and/or providing independent views and preferences is central to the negotiations. On the flip side, the kinds of cases the OCL would likely refuse include children under 8, unless part of a sibling group or special considerations exist. Primary issues are not ones where the OCL could be of assistance. For example, managing the relationship between a parent and the worker, monitoring hygiene issues in the home, improving communication between the parents and caregivers, or developing a circle of support for parental issues like addiction or mental health. If there is concurrent OCL involvement in another forum, such as a Section 112 report by a clinician, or if there is a very recent report, either OCL or private, OCL would likely not assign counsel, as the information is readily available in another format. In child protection mediation, the OCL is generally always present at the mediation session, where the assignment is only for the purposes of the ADR or openness issues. Where the OCL is providing representation in an ongoing court proceeding, the extent to which the OCL participates in the ADR will be determined on a case-by-case basis by the mediator or facilitator and the OCL. In family group conferencing, the OCL would not be present during the private family time, but would be present at both the initial stage of the conference and the final stage where the family presents their plan. The OCL is available to speak privately with the child as needed throughout the FGC. For Indigenous approaches to ADR, the OCL's level of participation is determined in consultation with the community and the ADR facilitator. Some other things to know about OCL participation are: the OCL lawyer will assign the agreement to mediate. The OCL may take notes during the ADR, as they are required to do so by their professional obligations, and their notes are privileged and not subject to disclosure. The mediator or facilitator's report, if any, will be made available to all participants, including the OCL. The OCL adds value to the child protection ADR process in the following ways. Often, children do not participate in the ADR, and therefore do not have the opportunity to speak for themselves as the adult participants do. Having an OCL brings the child's voice to the table. In some cases, there are additional issues for mediation that are important to the child but have not been raised by the other participants. The OCL can bring those issues to the table for consideration. Child's counsel can provide support to a child who does attend an ADR. Children aged 12 and over are entitled to participate in court proceedings and ADR meetings. Their participation is determined between OCL counsel and the child in consultation with the ADR service provider. The OCL has a solicitor-client relationship with our child clients, and therefore the child can discuss any issues with their OCL counsel in confidence. As the OCL is often the only lawyer present, the OCL can provide the group with legal information, not advice, to help shape the settlement. And, in addition to preparing the child for the ADR process and participating in the ADR with or without the child, the OCL also has a role, following the completion of the conference, to follow up on any plans agreed upon, monitoring implementation, referring to resources, and potentially assisting in ironing out any bumps in the implementation of the plan or agreement. One of the most important things that the OCL lawyer must do is establish early and effective communication and collaboration with the mediator or facilitator. This is the mediator or facilitator's process, and having a common understanding of the goals is key. It is also important for OCL counsel to keep in mind that unlike court, a successful ADR involves much more than just arriving at a final plan. Successes for our child clients can also include fostering and supporting safe family connections and relationships, working to shift power imbalances, partial resolution, or if the matter is returning to court, a narrowing of issues, so that there are fewer issues left to be decided by the judge. After confirming the family is willing to participate in an ADR service and consents to their information being shared with ADR-LINK and the ADR practitioner, complete the ADR referral form and provide as much detail as possible. Send the completed Office of the Children's Lawyer notification to the Office of the Children's Lawyer via fax to 416-314-8050 or email ocllegaldocuments@ontario.ca. Send the completed ADR referral form, all signed consents, the Office of the Children's Lawyer notification form, and proof that it has been faxed to the Office of the Children's Lawyer, to ADR-LINK@lfcc.on.ca, or fax the documents to 519-679-4234. All documents required to process a referral for this service can be found at www.adr-link.ca on the resources page. For further information about the Office of the Children's Lawyer, please consult the ADR-LINK website www.adr-link.ca or the Government of Ontario website www.ontario.ca/page/office-children's-lawyer.